You are on HOA Karma Files. I stayed calm and let her talk. Karen waved a cheap badge and screamed that she was Records Custodian and she could deny anything she wanted. I stood on my own porch in the drizzle, holding a notice that made no sense, while Donna Foster jabbed her finger at a laminated policy sheet and told me the rules were crystal clear. The notice is real and the fee is real, she shouted, even though the first letter said I had until Friday, and this one said I was already in violation as of Monday. I asked her which date was correct, and she said both, and that is when I knew this was not about compliance. I work as a telecom project coordinator in Grand Rapids, Michigan, and I live in spreadsheets and logs. So when Quarry Ridge Design Review Association sent me 2 letters in 3 days that contradicted each other, I did what I always do. I made a timeline. The first notice cited a gate code violation on March 2nd and gave me until March 10th to submit a written explanation. The second notice, dated March 4th but postmarked March 6th, claimed I had failed to respond by March 3rd and assessed a $50 late fee plus a $200 non-compliance penalty. I had not even received the first letter until March 5th. Donna stood on my porch step in a white bucket hat and a pink cardigan, both already dark with drizzle, and told me the postmark did not matter because the violation date was what counted. I asked to see the rule that said that. She told me she did not need proof, she had paperwork and vibes. That was the moment I remembered the old case. 3 years ago, a neighbor 2 blocks over had been hit with a surprise towing bill and an enforcement fee for parking in his own driveway overnight. The HOA claimed he had been sent warnings, but he swore he never got them. The board told him the records were confidential and refused to show him the certified mail log. He paid the fees and moved 6 months later. At the time, I thought it was just bad luck. Now I was holding 2 contradictory notices, and Donna was refusing to let me photograph the policy binder she kept waving, and I realized bad luck does not wear a badge and show up in the rain to tell you vibes count as evidence. I told Donna I wanted to see the full rule text and the enforcement log. She said the log was not public, and I could file a records request if I wanted to waste everyone's time. I said I would file one that afternoon. She said the custodian had the right to deny anything that was not specifically required by state statute, and gate access records were internal operational documents. I asked her who the custodian was. She smiled and tapped the cheap plastic badge clipped to her cardigan collar. It said Records Custodian in all caps under the HOA logo. I said I wanted to speak to the board president. She said she was the gate access administrator and this was her jurisdiction, and if I kept arguing, she would flag my account for daily compliance audits. I said almost nothing, because silence makes people talk. Donna filled the silence by telling me the HOA had been cracking down on gate abuse because too many residents were sharing codes with contractors and guests, and the association had hired a vendor to audit access logs and issue compliance notices. I asked for the vendor name. She said that was proprietary. I asked when the contract started. She said I was not entitled to contract details. I asked if the board had voted on the contract. She said the board delegated operational vendors to the compliance committee, which she chaired. I asked if the compliance committee met publicly. She said it met as needed, and minutes were filed internally. I said I wanted a copy of the minutes. She said the minutes were draft until approved, and she was not required to release drafts. The drizzle was picking up, and my porch was covered, but Donna stayed on the step getting wet because she wanted me to see her standing there like enforcement was a performance. I told her I would pay the fees under protest and file a formal appeal. She said appeals had to be submitted in writing with a $50 processing fee within 5 business days, and if I missed the deadline, the decision would be final and daily fines would start. I asked what the daily fine was. She said $25 per day until compliance was verified. I asked what compliance meant. She said a written acknowledgement that I understood the policy and a signed agreement not to share my gate code with unauthorized users. I said I had never shared my code. She said the audit log showed my code was used 6 times in 1 week, which indicated sharing. I said I used my code every day. She said not 6 times in 1 day. I said show me the log. She said the log was proprietary vendor data and I was not entitled to see raw operational records. That was when I knew this was not enforcement. This was a shakedown with a badge. I asked Donna how much the vendor charged per audit. She said that was not my concern. I asked if the vendor got a percentage of the fees. She blinked twice and said vendors were compensated per their contract terms. I said I wanted to see the contract. She said I could file a records request. I said I just did. She said verbal requests were not valid. I said I would send an email. She said the custodian had 10 business days to respond and could deny requests that were overly broad or burdensome. I said asking for one contract is not broad. She said the contract included proprietary pricing schedules and vendor trade secrets, so it would require redaction, and redaction required board counsel review and counsel charged by the hour. I asked if the HOA was going to bill me for the lawyer time. She smiled and said costs could be assessed to the requesting party if the request was deemed frivolous. I was paying for a family medical expense, and every bogus fee hurts, so I did not have the budget to lawyer up over $50. But I also did not have the budget to let Donna invent a new fee every week for the next year. I told her I would comply with the written acknowledgement requirement if she put the exact policy language in writing, so I knew what I was agreeing to. She said the policy was in the binder, and I could read it at the next board meeting if I attended. I said the meeting was not for 2 weeks and the deadline was 5 days. She said I should have planned ahead. I said the notice arrived yesterday. She said the violation date was 8 days ago, and ignorance was not an excuse. I asked how I was supposed to know about a violation I did not receive notice of until after the deadline. She said the notice was generated automatically by the vendor system and mailed the same day, so if I did not get it on time, that was a postal issue, not an HOA issue. A couple on the porch across the street stopped talking and just watched like it was a show. Donna noticed and raised her voice so they could hear. She said some residents think the rules do not apply to them, and the association has a duty to protect property values and neighborhood character. I said I was not trying to skip the rules, I was trying to understand which version applied. She said there was only one version, and if I was confused, that was a personal problem. I asked her to email me the current policy text. She said the policy was available on the resident portal. I said the portal link in the last email was broken. She said the portal had been updated, and I needed to reset my password. I said I tried, and the reset link did not work. She said that sounded like user error, and I should contact the management company. I said the management company told me to contact the board. She said the board did not handle password resets. I said then, how do I access the portal? She said I could visit the management office during business hours and request a printed copy for a $10 printing fee. I felt my jaw tighten, and I made myself take a breath. I told Donna I would go to the management office that afternoon and get a printed copy, and then I would submit my written acknowledgement before the deadline. She said the acknowledgement had to include my agreement not to share codes and my understanding that future violations would result in immediate gate code suspension. I asked what counted as a violation. She said any use pattern that the vendor flagged as suspicious. I asked for the criteria. She said the criteria were proprietary. I asked how I was supposed to avoid a violation if I did not know the criteria. She said responsible residents do not have that problem. Donna turned and walked back down my driveway, and as she passed the couple across the street, she said something I could not hear, but they both nodded. I went inside and pulled up the old case file I had saved 3 years ago when my neighbor got towed. I had kept a copy of his complaint email to the board because I was on the HOA email list back then, and it had seemed off. He had attached a photo of his truck in his driveway with a timestamp showing it was parked at 11 at night, and the towing invoice said the truck was towed at 6 in the morning for overnight street parking. But his driveway was clearly visible in the photo. I opened the image file and checked the metadata. The photo was taken on October 14th at 11:14 at night. The towing invoice was dated October 15th, but the creation date on the invoice PDF was October 12th. I screenshotted the metadata and started a new folder. I labeled it Audit Trail and dropped in the screenshot my 2 contradictory notices and the email thread with the management company about the broken portal link. Then I sent a records request email to the board, the management company, and Donna, asking for the gate vendor contract, the compliance committee minutes from the last 12 months, the enforcement log showing my alleged code sharing violations, and the current version of the gate policy. I copied myself and saved the sent timestamp. The management company replied in 6 minutes. They said records requests had to go through the custodian and they had forwarded my email to Donna. Donna replied an hour later. She said my request was overly broad, included proprietary vendor information, and required board council review. She said the review would take 10 business days, and the HOA reserved the right to assess costs. She said if I wanted to narrow the request to a specific document, she would consider it, but blanket requests for all committee minutes and vendor contracts were not reasonable. I replied and asked for just the current gate policy and the enforcement log entry for my account. She said the policy was on the portal, and the log was proprietary vendor data. I replied and said the portal was inaccessible and the log was the basis for the fee, so I was entitled to see the evidence. She said I was not entitled to raw vendor data, and the summary notice I received was sufficient. I called the management company and asked to speak to the property manager. The receptionist said the manager was out and would call me back. I said I needed to resolve a records access issue before a deadline. She said she would leave a message. I asked if anyone else could help. She said records requests went through the custodian. I said the custodian was stonewalling me. She said the management company did not get involved in disputes between residents and board members. I said this was not a dispute, this was a procedural question. She said I could file a complaint with the board president. I asked for the president's contact. She said board contact information was confidential and I could send an email to the general HOA address. I said I already did. She said she would make sure the message was forwarded. I hung up and checked my phone. The deadline was 4 days away, and I still did not have the policy text I was supposed to acknowledge. I looked at the invoice metadata again. If the PDF was created 2 days before the violation, that meant someone had backdated it. I pulled up the towing company name from the old invoice and searched for their website. They were still in business. I called and asked if they kept records of dispatch requests. The dispatcher said they kept logs for 7 years. I asked if I could request a copy of a specific dispatch. She said I would need to submit a written request with the invoice number and a notarized ID. I asked how long that took. She said 2 weeks. I thanked her and hung up. 2 weeks was past my deadline. I needed something faster. I opened the neighborhood Facebook group and searched for posts about towing. I found 4 complaints in the last 2 years, all citing the same vendor and all claiming they never got warnings. 2 of them mentioned Donna by name. One said she had shown up in person to verify the violation and refused to let them photograph the notice. Another said the towing company told them the HOA had requested the tow but would not provide a dispatch record. I screenshotted all 4 posts and added them to my audit trail folder. Then I went back to the old case and looked at the dates again. My neighbor had been towed on October 15th. The invoice PDF was created on October 12th. The complaint email he sent to the board was dated October 16th. The board reply was dated October 23rd, 7 days later. It said the board had reviewed the matter and determined the enforcement was valid, and the resident could appeal by submitting a written request with a $50 fee within 5 business days. My neighbor replied the same day and said he was past the deadline because the board took 7 days to respond. The board said the deadline was calculated from the violation date, not the response date. My neighbor paid the fees 2 days later and listed his house a month after that. I added the email thread to my folder and then I did the math. If the invoice was created before the violation, someone had to have access to the towing company system or the invoice template. I searched for Donna Foster and the towing company name together. Nothing. I searched for Quarry Ridge and the towing company. I found a single result, a business registry entry showing the towing company had filed an assumed name certificate listing an officer named Dennis Foster. I ran Dennis Foster and found a Michigan corporation record. He was the registered agent for the towing company. I ran Donna Foster and found her listed as treasurer on a different business, a property management consulting LLC that shared an address with the towing company. I printed everything and added it to the folder. Then I called a contractor I had worked with last year on a telecom site survey, a guy named Pete who did low voltage installs and did not take any garbage from anyone. I asked him if he remembered the HOA towing complaints. He said he had been towed once himself 2 years ago and fought it until the HOA threatened to put a lien on his business license. I asked him if he still had the paperwork. He said he kept everything. I asked if I could see it. He said he would bring it over. Pete showed up 20 minutes later in a work van with a file box. He pulled out a towing invoice, a notice from the HOA, and a dispatch log he had subpoenaed through small claims court before he dropped the case. The dispatch log showed the tow request came from a phone number registered to Donna Foster. The invoice was dated the same day as the tow. The PDF metadata showed it was created 3 days earlier. I took photos of everything and added them to my folder. Pete asked what I was doing. I told him I was building a timeline. He said if I was going after Donna, I wanted to be careful because she had friends on the board and a lawyer on retainer. I said I was not going after anyone. I was just trying to figure out why my notices did not match. He laughed and said that was how it started for him too. Pete asked me if I knew about the compliance committee. I said Donna told me she chaired it. He said the committee did not exist. He said he had requested the meeting minutes during his small claims case, and the board admitted there were no minutes because the committee had never met. He said Donna called herself the chair, but the board had never voted to create the committee. I asked how she got away with that. He said the board president was her cousin, and the property manager was afraid to push back, because Donna threatened to sue for defamation every time someone questioned her. Pete said he dropped the case because his lawyer told him it would cost more to fight than to pay, and the board had deeper pockets. I asked him if he would be willing to submit a statement to the board if I reopened the issue. He said he would do better than that. He said he would show up in person if I needed a witness, because Donna had cost him $300 and called him a liar in front of his own customers. I thanked Pete and told him I would let him know. He left and I went back inside and opened the resident portal one more time. The reset link still did not work. I took a screenshot showing the error message and added it to the folder. Then I sent another email to Donna and copied the board and the management company. I said I had attempted to access the portal as instructed and the system was broken. I said I had visited the management office and been told I needed to pay $10 for a printed policy, but the deadline was 3 days away and I could not comply with a policy I had not seen. I said I was requesting a 1-week extension to allow time for the portal to be fixed or for the management company to provide the policy by email at no cost. I said if the extension was denied, I would treat the deadline as unenforceable and dispute any additional fees. Donna replied in 15 minutes. She said technical issues were not a basis for extension, and I had been given adequate time to plan ahead. She said if I failed to meet the deadline, the daily fines would begin automatically, and my gate code would be suspended pending compliance. I replied and asked what compliance meant if I could not see the policy. She did not reply. The next morning, I got a knock on my door at 7. I opened it and found a man in a polo shirt with a vendor badge clipped to his belt. He said he was here to verify compliance with the gate access policy. I asked what that meant. He said he needed to confirm I was not sharing my code with unauthorized users. I asked how he was going to confirm that. He said he needed to see my phone and check my text messages and email for any instances where I had sent my gate code to anyone. I told him no. He said refusal to cooperate would be noted in his report and could result in additional fees. I said I did not consent to a search of my phone. He said this was not a search, it was a voluntary compliance verification. I said it was not voluntary if you were threatening me with fees. He said he was not threatening anyone, he was following the verification protocol authorized by the compliance committee. I asked for his name. He said his name was on his badge. I asked for his company name. He said he worked for the vendor contracted by the HOA. I asked for the contract. He said he did not carry contract documents in the field. I told him I was recording this conversation. He said that was fine. I took out my phone and started a voice memo. I asked him again to identify himself and his company. He said his name was Ron, and he worked for Secure Access Compliance. I asked if Secure Access Compliance was owned by Dennis Foster. He blinked and said he did not know the ownership structure. I asked if he was aware that Dennis Foster was married to Donna Foster. He said he did not know who that was. I said Donna Foster was the HOA records custodian and the person who had authorized him to come to my house. He said he was just following the work order. I asked to see the work order. He showed me a printout with my address and a note that said resident flagged for code sharing, verify compliance, document non-compliance if access denied. I took a photo of the work order. He said I was not allowed to photograph vendor documents. I said I just did. He said he was going to note that in his report. I said I was going to note that he showed up at my house at 7 in the morning and demanded to search my phone without a warrant. He said this was not a criminal matter. I said then you have no authority to demand anything. He said the HOA had the authority to enforce compliance. I said show me the rule that says you can search my phone. He said he did not have the rule book with him. I said then come back when you do. He said he would report that I refused to cooperate. I said you do that. If you are enjoying this investigation, make sure to like and subscribe for more satisfying payback stories. He walked back to his truck and sat in the cab for 5 minutes, typing on his phone. Then he drove away. I went back inside and added the photo of the work order to my folder. Then I called Pete. I told him what had just happened. He said the same thing had happened to him and he had filed a police report for trespassing. I asked if the police did anything. He said they took a report and told him it was a civil matter. I asked if the report helped in small claims. He said the judge did not care because the HOA lawyer argued the vendor had implied consent to verify compliance under the rules. I said the rules did not say that. Pete said the judge did not read the rules. I told Pete I was going to file a police report anyway because I wanted it on record. He said that was smart. I asked him if he still had the dispatch log showing Donna's phone number. He said he did. I asked him to send me a copy. He said he would email it. I thanked him and hung up. I called the non-emergency line and explained what had happened. The dispatcher said an officer would come by to take a report. 2 hours later, a deputy showed up. I walked him through the whole thing and showed him the work order photo. He said it sounded like a civil dispute. I said the vendor showed up uninvited and demanded to search my phone. The deputy said that was not a crime unless he forced entry or threatened violence. I said he threatened fees. The deputy said that was a civil matter. I asked if I could at least get a report number. He said he would write it up as a suspicious contact. I asked if that meant anything. He said it meant if the vendor came back and escalated, I could reference the prior report. I thanked him, and he left. I added the report number to my folder. Then I opened my email and saw a message from Donna. It was timestamped 20 minutes after the vendor left. It said I had refused a lawful compliance verification, and the HOA was assessing an additional $100 obstruction fee and suspending my gate code effective immediately. I replied and said the verification was not lawful because I did not consent, and the vendor had no legal authority to search my phone. She replied and said consent was implied by residency and acceptance of the governing documents. I replied and said show me the rule. She replied and said the rule was in the policy I had refused to access. I replied and said the portal was broken. She did not reply. My gate code was suspended 2 hours later. I found out when I tried to leave for work and the gate would not open. I had to back up and wait for another car to trigger the exit sensor. I called the management company and told them my code was not working. The receptionist said my account was flagged for non-compliance and I needed to contact the compliance committee. I said there was no compliance committee. She said she was just reading what was in the system. I asked who entered the flag. She said she did not have access to that information. I asked to speak to the property manager. She said the manager was in a meeting. I said I would hold. She said the manager was not available. I said I would call back every hour until someone talked to me. She said that would not change anything. I hung up. I called Pete and told him my code was suspended. He said they did that to him too. I asked how long it took to get it back. He said 3 weeks, and by then he had already paid the fees. I said I was not paying. He said then you better have a good lawyer. I said I had something better. I had a timeline. That night I went to the management office and waited in the lobby until the property manager came out. Her name was Lynn and she looked exhausted. I told her I needed 5 minutes. She said she could not discuss resident disputes. I said this was not a dispute, this was a records access issue. She said records requests went through the custodian. I said the custodian was blocking my access and charging me fees for requests she was required to provide. Lynn said she could not override the custodian. I said the custodian was violating state open records law. Lynn said that was a legal question and I needed to talk to the board attorney. I said I wanted the attorney's contact information. She said board attorney information was confidential. I said, then how do I file a complaint? She said I could email the board. I said I already did. She said she could not help me. I asked her if she was aware that the compliance committee had never met. She looked at me for a long time and said she could not comment on internal board operations. I said that was a yes. I asked Lynn if she was aware that Donna Foster was married to the owner of the towing company. She said she was not aware of that. I asked if she was aware that the towing invoices had been backdated. She said she was not aware of that. I asked if she would be willing to review evidence of that. She said she could not participate in resident disputes. I said this was not a dispute, this was fraud. She said if I believed fraud had occurred, I should contact law enforcement. I said I already filed a police report and they said it was a civil matter. She said then I should contact an attorney. I said I was trying to resolve this without an attorney. She said she could not help me. I asked her if she had a file copy of the gate access policy. She said the policy was on the portal. I said the portal was broken. She said she would put in a ticket with IT. I said I needed the policy today because my deadline was tomorrow. She said she could print a copy for $10. I said I would pay the $10. She printed the policy and I handed her a $10 bill. The policy was 3 pages long. I read it in the lobby. It said gate codes were for personal use only, and residents were required to report any suspected misuse. It said the HOA could suspend access for violations pending a hearing. It said hearings would be scheduled within 30 days of a suspension. It did not say anything about compliance verifications or phone searches. It did not say anything about obstruction fees. I took the policy back to Lynn and asked her to show me the section that authorized the vendor to search my phone. She read it and said it was not in there. I asked her to show me the section that authorized obstruction fees. She said it was not in there. I asked her if that meant the fees were invalid. She said she was not authorized to make that determination. I asked who was. She said the board. I thanked Lynn and left. I went home and added the policy to my folder. Then I wrote a formal appeal. I attached the timeline, the metadata screenshots, the Facebook complaints, the towing dispatch log Pete had sent me, the police report number, the vendor work order, and the policy Lynn had printed. I listed every fee Donna had assessed and explained why each one was invalid. I sent it to the board, the management company, and Donna, and I copied my attorney in case I needed one later. The attorney was a friend from college who did real estate law and had agreed to review my case for free as a favor. She emailed me back in an hour and said I had a strong case and the HOA was going to settle as soon as they realized I had documented everything. Donna replied in 10 minutes. She said my appeal was untimely because I had missed the 5-day deadline. I replied and said the deadline was unenforceable because I had not been provided the policy text. She replied and said I had been told how to access the policy and my failure to do so was not an excuse. I replied and said the portal was broken and the management company had charged me $10 for the printed copy, which proved the HOA had failed to provide access. She replied and said the $10 fee was a standard cost recovery charge and did not constitute a failure to provide access. I replied and said the policy did not authorize phone searches or obstruction fees, and I was demanding an immediate reversal of all fees and restoration of my gate code. She did not reply. The next morning, I got an email from the board president. His name was Ed, and he was Donna's cousin. He said the board had reviewed my appeal and determined it was premature because I had not exhausted the compliance process. He said I needed to complete the verification and submit the written acknowledgement before the board could consider an appeal. I replied and said I had completed the verification by refusing consent, and the policy did not require me to submit to a phone search. He replied and said the board had discretion to interpret the policy, and the compliance committee had determined that verification included reasonable inspection. I replied and said the compliance committee had never met. He did not reply. I called my attorney friend and told her what was happening. She said the HOA was stalling because they knew I had them. She said I should send a demand letter threatening litigation and a complaint to the state licensing board if they did not reverse the fees within 7 days. I asked if that would work. She said it would work if they had any sense. She drafted the letter and I sent it that afternoon. Donna replied in an hour. She said I was being hostile and disruptive, and the board was considering additional sanctions for harassment. I replied and said documenting fraud was not harassment. She replied and said I was making false accusations, and the board reserved the right to pursue defamation claims. I replied and said truth is an absolute defense. She did not reply. 2 days later, I got a notice in the mail. It said the board had scheduled a special meeting to address my conduct, and I was required to attend. The meeting was in 3 days. I emailed the board and asked for the agenda. Ed replied and said the agenda was to discuss my non-compliance and disruptive behavior. I replied and asked if I would have an opportunity to present my evidence. He replied and said the meeting was not a hearing, it was a board discussion, and I could make a brief statement if time allowed. I replied and said I wanted to submit my evidence in advance so the board could review it. He replied and said the board had already reviewed my materials and did not require additional submissions. I showed up at the meeting with my binder and Pete. The meeting was in the community center and there were maybe 15 people in the room. Donna was sitting at the front table with Ed and 2 other board members. She was wearing the pink cardigan and the cheap badge. When I walked in, she whispered something to Ed and he nodded. I sat in the second row and Pete sat next to me. Donna looked at Pete and then looked at Ed. Ed said the meeting was for residents only and guests needed to leave. I said Pete was here as a witness. Ed said witnesses were not allowed unless they had been subpoenaed. I said this was not a trial. Ed said the board had rules for meetings and guests were not permitted during executive sessions. I said the notice did not say this was an executive session. Ed said the board had the discretion to move into executive session at any time. I said executive sessions were for confidential matters, and this was a compliance dispute. Ed said the board had determined my conduct raised confidential personnel issues. I asked what personnel issues. Ed said he was not required to explain board decisions. Pete stood up and said he would wait outside. Ed called the meeting to order and said the board had received complaints about my behavior and needed to address the matter before it escalated further. I said I had not received any complaints. Ed said the complaints were submitted to the board and were confidential. I said I had a right to know who was accusing me of what. Ed said the board was not required to disclose complainant information. I asked if Donna was the complainant. Ed said that was confidential. I said if Donna was the complainant, then this was a conflict of interest and she should recuse herself. Donna said she was not required to recuse herself because she was acting in her official capacity as records custodian. I said the records custodian position did not give her authority to block lawful requests. She said I was not making lawful requests. I was making harassing demands. I said show me one demand that was harassing. She said my tone in emails was hostile and accusatory. I said my tone was factual. She said I had accused her of fraud. I said I had documented a pattern of backdated invoices and suspicious vendor relationships. She said I was making false accusations without evidence. I said I had a binder full of evidence. Ed said the board was not here to litigate my claims. I said then why am I here? Ed said the board was here to address my non-compliance. I said I had not violated any rule. Ed said I had refused a compliance verification. I said the verification was unlawful. Ed said the board had determined it was lawful. I said the policy did not authorize phone searches. Ed said the board had discretion to implement reasonable measures. I said phone searches were not reasonable. Ed said the board disagreed. Donna leaned forward and said she had tried to work with me and I had been uncooperative at every step. She said I had refused to access the portal, refused to pay for a printed policy, refused to comply with the verification, and then filed a baseless appeal full of conspiracy theories. She said I was wasting the board's time and the association's money, and the board needed to take action to protect the community. I asked her if she was aware that the towing company was owned by her husband. She said that was irrelevant. I said it was a conflict of interest. She said her husband's business dealings were not relevant to HOA enforcement. I said they were relevant if the HOA was paying her husband to tow cars based on backdated notices. She said that was a false accusation. I said I had metadata proving the invoices were created before the violations. She said metadata could be manipulated. I said then let's get the original dispatch logs from the towing company. She said the towing company logs were proprietary. I said I already had a copy. She blinked. I opened my binder and pulled out the dispatch log Pete had given me. I slid it across the table. Ed picked it up and read it. He looked at Donna. She said the log was taken out of context. I said the context was that the tow was requested from her personal phone 3 days before the violation was reported. She said she had called to get a quote. I said, why would you call for a quote before the violation happened? She said she had noticed the violation in advance and wanted to be prepared. I said the violation was overnight street parking and the truck was in the driveway. She said the truck was on the street. I pulled out the photo my old neighbor had sent. I slid it across the table. The photo showed the truck clearly in the driveway with the timestamp visible. Ed looked at Donna. She said the photo was edited. I said the metadata showed it was unedited. She said I was harassing her. Ed said the board needed to take a recess. I said I was not done. Ed said the board was taking a recess and we would reconvene in 15 minutes. Donna stood up and walked out. The other 2 board members followed her. I stayed in my seat. Pete came back in and asked what happened. I said I showed them the dispatch log and Donna panicked. Pete said good. I said I was not done yet. When the board came back, Ed said they had discussed the matter and determined that the fees would be reversed pending further investigation. I said I wanted my gate code restored immediately. Ed said the code would be restored once the investigation was complete. I said the investigation was complete. Ed said the board needed time to review the materials. I said the board had already reviewed the materials. Ed said the board needed to consult with counsel. I asked how long that would take. Ed said he could not give a timeline. I said I wanted a timeline. Ed said the board would notify me when the investigation was complete. I said that was not acceptable. Ed said the meeting was adjourned. Donna stood up and walked toward the door. I called after her and said I was not done. She said, I am calling management and I am going to be dramatic about it. I said you already did. She left. I walked out with Pete and we stood in the parking lot. Pete said Donna was going to try to bury this. I said she could not bury it because I had too many copies. Pete said she would try anyway. I asked him if he had any other evidence from his case. He said he had kept everything, but most of it was the same stuff I already had. I asked if he had any emails from Donna. He said he had a few where she threatened him. I asked him to forward them. He said he would send them tonight. I went home and opened my email. There was a message from Ed. It said the board had voted to place me on probationary status pending the outcome of the investigation. I replied and asked what probationary status meant. He replied and said it meant any further violations would result in immediate fines and possible legal action. I replied and said I had not committed any violations. He did not reply. Pete sent me the emails an hour later. In one of them, Donna had told Pete that if he continued to dispute the fees, she would report him to the state licensing board for operating without insurance. Pete had replied with a copy of his insurance certificate. Donna had not replied. In another email, Donna had told Pete that she had personally witnessed his truck parked illegally, and if he called her a liar again, she would sue him. Pete had replied and asked for the date and time of the alleged witnessing. Donna had replied and said she did not keep a log of her personal observations. Pete had replied and said that was convenient. Donna had not replied. I added the emails to my binder, and then I sat down and wrote a formal complaint to the state HOA licensing board. I attached the full timeline, the metadata, the dispatch logs, the Facebook posts, the policy that did not authorize the fees, and Pete's emails. I explained that Donna had been using her position as records custodian to block access to evidence, while her husband's company profited from enforcement actions based on backdated paperwork. I said this was a conflict of interest and a violation of fiduciary duty. I asked the board to investigate and suspend Donna's access to HOA records pending the investigation. I mailed the complaint the next day with delivery confirmation. 3 days later, I got a call from a state investigator. She said she had received my complaint and wanted to schedule an interview. I said I was available anytime. She said she would come to my house the following Tuesday. I said that was fine. She asked if I had the original documents. I said I had everything. She said she would need to see the originals and make copies. I said I would have them ready. The investigator showed up on Tuesday with a briefcase and a recorder. Her name was Lisa, and she was a former property manager who had moved into enforcement. She asked me to walk her through the whole timeline. I did. She took notes and asked questions. She asked if Donna had ever directly threatened me. I said she had threatened fees and gate suspension. Lisa said she meant physical threats. I said no. Lisa asked if I had any evidence that Donna had personally profited from the enforcement actions. I said I did not have direct evidence, but I had the business registry showing her husband owned the towing company, and her LLC shared an address with the towing company. Lisa said that was circumstantial, but worth investigating. She asked if I had reported this to the board. I said I had. She asked what the board did. I said they put me on probationary status and told me to wait for an investigation. Lisa said that was retaliation. I said that was what I thought. Lisa asked if I had any other witnesses. I said Pete would talk to her. She asked for his contact information. I gave it to her. She asked if I had filed a police report. I said I had. She asked for the report number. I gave it to her. She said she would follow up with the police. She asked if I had any other documentation. I said I had Facebook posts from other residents. She asked for screenshots. I printed them and handed them over. She made copies and handed the originals back. Lisa said she was going to interview Donna and the board members. She said it would take a few weeks to complete the investigation. She said I should not have any contact with Donna during the investigation. I said Donna had not contacted me since the meeting. Lisa said good. She said if Donna contacted me, I should document it and let her know immediately. I said I would. She packed up her briefcase and left. 2 weeks later, I got an email from Ed. It said the board had completed its internal investigation and determined that the fees were issued in error. The email said all fees would be reversed and my gate code would be restored immediately. The email said the board was implementing new procedures to prevent future errors. The email said the matter was closed and no further action was needed. The email did not mention Donna. The email did not mention the towing company. The email did not apologize. I replied and asked what the new procedures were. Ed did not reply. I replied and asked if Donna was still the record's custodian. Ed did not reply. I replied and asked if the compliance committee was being dissolved. Ed did not reply. I called Pete and told him about the email. He said the board was trying to bury it. I said they could not bury it because the state was investigating. Pete said the state investigation could take months and the board was hoping I would drop it. I said I was not dropping it. Pete said good. A week later, I got a call from Lisa. She said she had completed her interviews and found multiple violations. She said Donna had failed to maintain proper records, had blocked lawful records requests, and had failed to disclose her conflict of interest with the towing company. She said the board had failed to oversee Donna and had retaliated against me for filing a complaint. Lisa said the state was issuing a consent order requiring the HOA to implement a management audit, remove Donna from the records custodian position, and refund all fees collected under the invalid enforcement actions for the past 3 years. Lisa said the consent order also prohibited the HOA from taking any retaliatory action against me or Pete. Lisa said if the HOA did not comply, the state would suspend the HOA's registration and impose fines. I asked Lisa if Donna would face any personal penalties. Lisa said Donna would be banned from holding any HOA board position or records custodian role for 5 years. Lisa said if Donna violated the ban, she would face criminal charges. I thanked Lisa and hung up. The consent order was posted on the HOA website 2 days later. It included a notice that the board was freezing all enforcement actions pending a policy rewrite. It included a notice that Donna Foster was no longer authorized to act as records custodian or access HOA records. It included a notice that all residents who had been assessed fees under the gate access policy in the past 3 years could request a refund by submitting a written request to the management company. It included a notice that the HOA had hired an independent auditor to review all vendor contracts and identify any conflicts of interest. I printed the consent order and added it to my binder. Then I sent a copy to my old neighbor who had been towed 3 years ago. He replied an hour later and said he was filing for a refund and he could not believe I had pulled it off. I told him it was not just me, it was Pete and Lisa and everyone else Donna had squeezed. He said he was buying me a beer. I said I would take him up on that. Pete called me that night and said he had seen the consent order. He said Donna was finished. I said she brought it on herself. Pete said he was filing for a refund too. I said he should. Pete said he was also filing a complaint with the Better Business Bureau against the towing company. I said that was a good idea. The next week, I got a letter from the HOA attorney. It was a settlement offer. The HOA agreed to refund all fees I had been assessed, restore my gate code, issue a written apology, and agree to a no-contact directive prohibiting Donna from contacting me or entering my property. The letter said the HOA would also pay for a policy review by an independent attorney to ensure the gate access policy complied with state law. The letter said in exchange I would agree not to file a civil lawsuit against the HOA or Donna. The letter said the offer was good for 10 days. I called my attorney friend and read her the offer. She said it was a good offer and I should take it. I asked if I should push for more. She said I could try, but the HOA had already given me everything I asked for, and they were probably hoping to close the matter before the audit exposed more problems. I said I wanted to make sure the no-contact directive had teeth. She said the directive should include a penalty clause for violations. I asked her to draft a counteroffer. She said she would have it ready by the end of the day. I sent the counteroffer the next morning. It accepted the settlement terms, but added a penalty clause requiring the HOA to pay me $1,000 per violation of the no-contact directive, with violations defined as any direct or indirect contact initiated by Donna, any attempt to access my property or records, or any retaliation for my compliance. The counteroffer also required the HOA to include the penalty clause in the settlement agreement and record it as a covenant running with my property, so it would survive any board changes. The HOA attorney replied the same day and said the board accepted the counteroffer. The settlement agreement was signed a week later. I got a check for $450 covering all the fees Donna had assessed. I got a written apology from the board president acknowledging that the fees were issued in error and the verification process was not authorized by the policy. I got a signed no-contact directive with the penalty clause recorded as a property covenant. I got a copy of the revised gate access policy that eliminated the compliance verification requirement and required all vendor contracts to be approved by a board vote in a public meeting. The management audit was completed 2 months later. It found that Donna had awarded the towing contract and the gate vendor contract to her husband's companies without board approval or competitive bidding. It found that the compliance committee had never met and had no minutes on file. It found that Donna had deleted records requests from the HOA email system to avoid responding to them. It found that the towing company had been paid over $30,000 in the past 3 years for enforcement actions based on notices that could not be verified. The audit recommended that the HOA terminate all contracts with vendors owned by Donna or her husband, adopt a conflict of interest policy, and implement a records retention policy with annual audits. The board adopted all the recommendations. Donna resigned from the board the day the audit was posted. The towing company lost the HOA contract. The gate vendor lost the HOA contract. Ed resigned as board president 2 weeks later, after residents started asking why he had let his cousin run enforcement without oversight for 3 years. I saw Donna once more after that. She was getting into her car at the grocery store and I was walking past. She looked at me and I looked at her. She opened her mouth like she was going to say something and then she closed it and got in the car and drove away. I never saw her again. The HOA held a special election and elected 3 new board members. One of them was Pete. The new board hired a new management company and implemented quarterly town halls where residents could ask questions and review financial reports. The gate access policy was simplified to a single page. The compliance committee was dissolved. The records custodian position was eliminated, and records requests were handled by the management company with a 10-day response deadline and no fees. I got my gate code back. I got my $450. I got my apology. I got my no-contact directive. And I got the satisfaction of knowing that the next time someone gets a bogus notice, there is a paper trail showing exactly how it happened and exactly how to fight it. I appreciate you hanging in there.